Welcome everyone to the Federal Bar Association Key Tam Sections, the rounds, FCA News with Tejinder Singh. I'm Scott Oswald. I am chair of the Key Tam section with Tejinder Singh, who's a partner at Sparacino PLLC. Tejinder, tell us about your new firm.
Yeah, I just changed jobs. It's an exciting change. So for those who have known me for a while, I've been at Goldstein and Russell for about 11 years, had a wonderful time with great colleagues doing Supreme Court and appellate work. And now I have moved along, and the idea is to start doing really a bit more work in the trial courts. I'm still going to have a hand in the Supreme Court and appellate stuff, but I'm branching out and trying to do more and different and exciting things. It's still going to involve quite a bit of whistleblower work, but we're also doing some exciting things under the Anti-Terrorism Act, helping American soldiers and their families who've been injured by terrorists and others. And so I'm excited about this next chapter and to keep on exploring this area of the law with you.
Well, Tejinder, congratulations from all of us. And we're so pleased that you'll be keeping us kind of in tune with what's been happening in the FCA world at our circuit courts and district courts. So thanks for staying aboard with us. So let's talk about what is in the news today. Let's first just touch on the 11th Amendment immunity issue. We kind of went over it a little bit during last episode. Now we have United States versus Florida Birth-Related Neurological Injury Compensation Association. This is a procurement opinion out of the 11th Circuit affirming a denial of a motion to dismiss on the grounds that the defendant, a state organized insurance kind of tight pool, was not subject to suit under the FCA and the 11th Amendment. And this is the 11th Circuit now weighing in. What did the 11th Circuit have to say?
So as we know, the Supreme Court has said that states and arms of the state can't be defendants under the False Claims Act. And so there are a lot of entities that are sort of peripheral to state governments that are tempted to raise 11th Amendment immunity as a way to get out of liability. And what the 11th Circuit does, so the district court in this case denied the motion. And the defendant was able to appeal under what's called the collateral order doctrine, which is a doctrine that says that even though the denial of immunity is not a final judgment per se, it's sufficiently final in its own insulated world to be immediately appealable. And so the defendant is able to take an immediate appeal from the denial of its motion to dismiss. And on appeal, the 11th Circuit straightforwardly affirms. It says there are 4 factors that the court will consider in deciding whether that something is a state entity: how state law defines the entity, what degree of control the state has over the entity, where the entity gets its funds, and who's responsible for judgments against the entity. And the idea, as you can imagine, is that the more these financial obligations fall on the state, the more the state is functionally controlling the entity, the greater the entitlement to immunity. In this case, which ends up being an unpublished decision, the 11th Circuit just walks through the factors and says this particular entity is not an arm of the state of Florida and is therefore not immune. And the particular facts are not sort of going to be broadly interesting, I don't think, but it does show that this issue is being litigated somewhat frequently, that it's always an appellate issue because either the defendant or the plaintiff can take it up no matter how it goes, and that the test is now getting pretty well settled.
So let's turn to efforts by the relator to keep something secret in the FCA process. First, the Ninth Circuit deals with the issue of when a relator can keep his or her name secret. This is a case, Roe versus Stanford Healthcare. How did the relator end up with its efforts to keep its name from the general public, Tejinder?
So yeah, this is a case where a relator filed as Emily Roe and sought to pursue an FCA case anonymously. Now, the case itself is dismissed. It fails under the public disclosure bar, so the case is not going anywhere. But the relator says, hey, keep me anonymous anyway. And there's sort of a well-settled test about when a party can litigate anonymously. Often what happens is a party says, hey, I face some real risk or consequences. And you can imagine this coming up all the time in the FCA context, where whistleblowers have frequently been blacklisted or had career consequences as a result of blowing the whistle. So they'll say something about the harm that they're going to suffer, and courts will effectively do a balancing test of that interest against the public's interest in knowing how the court system is being used, or the defendant's interest in knowing how they're being sued. Now, it's almost never the case that a relator can sue and the defendant will never find out who that person is. It is the case, though, that sometimes the relator can keep their names off public dockets. And that's basically what the Ninth Circuit says the relator can do here. Says the defendants already know who this person is, there's no unfairness to them, and there's some risk of retaliation here, so okay, it's fine. But doesn't really get into details at all. The whole analysis is about one paragraph.
So the relator in another case out of the Southern District of New York, United States ex-rel SFN Partners versus Post-Acute Partners, a case from April, trying to keep documents sealed at the end of a case. How did the relator end up here?
Yeah, so there's a different outcome here, and the relator is looking for slightly different relief as well. What the relator does in this case is files, it's a corporate relator, files a complaint under seal. The United States says, we're not going to intervene. And then, as often happens, the relator says, well, we're voluntarily dismissing, we don't want to go forward. But also says to the court, don't ever unseal this or reveal the details in the complaint. And they don't have really much of an explanation for why they want to keep this stuff secret. They say there is financial information that we got through FOIA type requests that shouldn't be made public. And the district court says, what are you talking about? This is effectively public information already. There's no reason to keep that information out of the public domain. And the court talks about how there is a strong norm of presumptive access to judicial filings, which in this case has no countervailing interest against it. And so the request to keep the whole thing under seal forever is denied, and the docket is unsealed.
And so in general, this kind of adds to a trend in the courts, at least at the back end. Relators aren't doing so well in trying to keep aspects of the case under seal.
Yeah, I think that's right. I think that what it shows is that if your big concern is your identity being revealed, then probably the right procedure is to file anonymously in the first instance and to really consult the local rules of whatever court you're in about how to do that. Courts are all over the map in terms of what procedures they require for anonymous filings. Some want a motion right away, some will let you do it until somebody complains. But it's really important to understand what your local jurisdiction does and even what your individual judge does, because there's a lot of variation. But that's the way to protect your identity, is to file anonymously and to articulate the reasons at the appropriate time for why you need that protection. I think trying to keep entire dockets under seal is going to be a more anomalous procedure, but I have heard tell, and I don't know if you've heard about this, of certain jurisdictions where unless the government affirmatively asks for unsealing, the court just kind of puts the file on a shelf and never unseals it. So I know that does happen sometimes.
It does, and we'll never know because it's not out there in the public domain, right?
Yeah, that's right. So this is a place where I guess experienced FCA practitioners will have some wisdom to communicate to potential relators about jurisdictions where it might be possible to file in this posture. But I would say in general, I wouldn't count on it, because unless there's something compelling, courts are going to be inclined to disclose information unless they have some quirky rule that says they don't.
So let's finish up with a topic that we've been turning to now over and over again on this program. That is kind of put front and center by U.S. ex-rel Proctor versus Safeway, a 2-1 decision out of the Seventh Circuit in April. Citing Safeco, the Seventh Circuit holds that Safeway was acting under a reasonable interpretation of law when it billed the government for higher prices than those it charged its uninsured customers. What does this give us, Tejinder? How does this add to what is growing case law in this area?
Yeah, so this again goes to this scienter question of, can a defendant say we have a reasonable interpretation of the law, even though it was wrong, and therefore we didn't submit false claims? And the Seventh Circuit has staked out this kind of extreme position that says, if the defendant's conduct falls within an objectively reasonable interpretation of the law, the defendant wins unless the defendant was warned away from that interpretation by authoritative guidance. What's really, to me, quite striking about the Seventh Circuit's rule is that it doesn't matter whether the defendant actually believed that reasonable but wrong interpretation at the time it presented the claims. It could have totally thought that it was breaking the law, and it was breaking the law, but it didn't act knowingly if later on the lawyers can say, oh, there was this reasonable interpretation that we weren't warned away from. And so that was the rule that was announced in the Schutte versus SuperValu case, which is currently, there's a cert petition filed. I represent the relator in that case. I actually also represent the relator in this Safeway case, and you can expect a cert petition there as well. And this case is really a follow-on to what happened in Schutte. It's a similar type of scheme resulting in a similar defense being raised. And even, the dissenting judge, Judge Hamilton, is the same in both cases and making essentially the same points, that the reason this is wrong is that if you believe what you're doing is unlawful, that's enough to act knowingly under the FCA. And so that will be what the debate is about, is that enough?
And the reason that this is so important to Tejinder is because what it does is it creates this issue now is a matter of law subject to summary judgment, as opposed to something that a jury would suss out, right?
Yeah, that's right. And it wouldn't even necessarily have to be summary judgment, right? You could see a lot more decisions at the pleading stage where the defendant says, it doesn't matter what we subjectively believed. It only matters if we can point you to an objectively and reasonable interpretation of the law that the alleged conduct in the complaint would fall under. And if so, we win. And so, yeah, I do think it's going to be adjudicated much more as a matter of law with less discovery into the state of mind of the defendants. And so there are going to be a lot of cases where the defendants may have believed they were doing something wrong, but we'll just never know because we'll never get to the point where those questions are even asked.
So what's on the horizon for this subject, both in the circuit courts and maybe in the Supreme Court?
There is a cert petition pending, as I noted in the Schutte case, that's been filed. As of now, the defendants are due to respond on May 19th, but they may take an extension. This seems like the type of case where it is highly likely that the court will call for the views of the Solicitor General. The court does that when the federal government has an obvious interest in a case between private parties. And their False Claims Act cases are fertile ground for this because the government has such a strong financial interest and also law enforcement interests. And this has also been a case where the government has actually already taken the unusual step of filing briefs in support of petitions for rehearing, where it's arguing, hey, this SuperValu decision is wrong, similar decisions are wrong, and really need to be corrected. And so I would assume, although it's never easy to predict, that this is the type of case in which the court is likely to seek the government's views on whether it should take up the case.
Sounds like we got a lot more to talk about on this subject in future episodes. Tejinder, thank you, and thank all of you for joining us. We look forward to seeing you for the next edition of The Rounds with Tejinder Singh.